All right. Good morning. Today is May 29th, 2014. Calling the meeting to order. First of all, let's do a roll call. Let's start with Alvin.
Whitney Clark, Licensing Services.
Michael Almondar, Licensing Services.
Dan Shapiro, Licensing Services Counsel's Office.
Mark Mastrobuno, Licensing Services.
Donna Dollar, Licensing Services.
Mary Jo Moore, Licensing Services.
Linda Cleary, Licensing Services and Counsel's Office.
Carol Fansler, Licensing Services.
Jody Delala, Licensing Services. Amy Duncan, Licensing Services.
Duncan McKenzie, Board Member.
Yes.
Eileen
Your
Stone,
turn.
Board Member. Tricia O'Connor Francis, Board Member.
Sandra Erickson, Board Member.
Dale Burnett, Board Member.
Diane Ramirez, Board Member.
Dan Burstein from the Department of Financial Services, Board Member.
Jack Colello, Licensing Services.
Marcos Vigil, Deputy Secretary on behalf of the Board Chair, Secretary of State Cesar Perales. So I believe we have one person on its way to Buffalo, but it appears that for the moment we do have quorum.
Great.
Nobody from Buffalo showed.
All right, thank you.
You're welcome.
We are expecting Joe Burko. He said he'd be about a half hour late, but that's still only 7.
All right, so
We need 8.
1, 2, that would be 7. And for purposes of the quorum, do DFS and the chair count?
No, they're ex officio.
They have voting rights in the statute? I think they do.
Do they have voting rights?
Yeah.
Do
You have to count them in the number.
Yeah, we've counted
Yeah,
before.
count the
We've
number
counted before
divide-
for purposes of quorum.
Okay.
Yeah.
All right. They have voting rights. We have the copy of the statute.
There was a time when I could do this by memory, but now I don't. I apologize.
No,
We have
already
a
has
copy
it.
of the statute? Why don't we conduct business, because we won't get to a vote for a bit, and I'll give you my answer in about a minute. Sound good?
Thank you. Yes. Well, before we start the meeting anyways, I wanted to make a couple of official announcements. All of you received the email announcing the official promotion of Whitney Clark to the position of Director of Licensing Services. We're extremely happy about that promotion in the department. As all of you know, over the past 10 years, Whitney has been serving as counsel for the division, particularly working really hard with this board, collaborating with all of its members, and doing a great deal of work for it. Recently, Whitney was also distinguished by being selected to participate in a governor's special program and became certified as an Empire State Bill for lien processing. And one of her first projects was actually working to streamline the application process for real estate brokers with the department. And later on during our discussion, she's going to go into that. But she has already stepped into the role and started to make some changes in the division. We're very happy about that. And also, as you saw, we're gladly welcoming back Dan Shapiro to the role of program counsel for purposes.
Which role do you want me in? Pleasure.
Good for you, Whitney. Thank you very much.
So let's keep the approval of the summaries for the April 24th and August 14th, since we would require to have quorum in order to have those approval. And the first item then on the agenda is the continuing education audits. I was already giving a premiere of some of those findings to the folks here in New York, but I'll send it over to Albany to discuss.
Good morning, Jody DeLallo. I just wanted to report that we've continued to conduct continuing education audits for sales and brokers. At this point, the compliance rate is not as high as we would like. On a monthly basis, non-compliance is anywhere from 20 to 30%, non-compliance. So one of the things we've discussed is trying to get the information out to the industry. And one of the things that we can do is send a notification to all the brokers through our e-access system, informing them that we do audit renewals, that they should ensure that they themselves and their salespeople complete continuing education prior to renewing their licenses, because if they don't comply, they are subject to disciplinary action. So we're hoping that at least getting the word out there, spreading the word, so to speak, will improve compliance rates. We can send the notification on behalf of the board if that's appropriate, and take it from there and see if that'll at least improve. We don't want to penalize people. We want them to take their continuing education. So if we get the word out there and they talk to their salespeople, it may improve. We're hoping. So that's where we are with that.
Jody, could you share how many audits have we conducted so far and the specific number of non-compliance?
Yeah, since July, we've audited nearly 1,200 people. Like I said, on a monthly basis, the compliance rate is, specifically has been between 71 and 83%. So with an average of maybe 78% compliance on average. But and that's out of 1,200 salespersons and brokers.
So what action are you taking when you find someone? I'm sorry. What action are you taking when you find somebody who hasn't? What's the initial action?
Well, we send them a letter letting them know what their options are for compliance are. They get a second chance to provide proof that they completed the education. They can request an administrative hearing, and that'll the law judge will determine the penalty. We send them a consent order that they agree to, and that includes a fine for non-compliance, and then they still have to complete the continuing education. Or we give them the option to surrender their license. If they choose to surrender their license, they can reapply after a year. They can retake the state exam and reapply after the year. So those are the options at this point.
Gotcha.
I'm putting on my lawyer hat again for a second. The way that we look at these types of violations, there's actually two. There's a violation for failing to complete the continuing education, and there's a violation for lying on the application.
Can I ask you, the answer was very good and clear, but does that include the supervisory broker? Are they assigned a penalty because they're supposed to have supervised?
We haven't been doing that at the moment. That's certainly an option if our rates don't improve.
I have something. This is just a suggestion, and we have spoken about this before. I'm also licensed in New Jersey, and when you want any agency that offers CE has to input that information into a system that is linked with DOS. So if I come to renew my license, it will not allow me because the system already shows that I don't have CE. And that will typically, remove the auditing, because guess what? You just won't get licensed. Because if your school did not input your hours, then you don't have them. Go get them and then come back and renew.
Can I just mention I'm a licensed insurance broker, and that's what they do. The school sends it into the New York State Insurance Department, and you cannot renew unless you've taken the CE.
And this could be all digital.
Yeah, so maybe
Yeah, as you all know,
We could work
the
towards
current
that.
system that we have has its limitations, and we are looking to upgrade the system
Right.
into with the new e-licensing program, and that's definitely, a component that Amy can start looking into for purposes of that. Amy, can you speak to that a little bit?
Oh, yeah, we have an e-licensing system that we've been moving forward on. It's a phased approach. It's an enterprise level system, so it's going across agencies. Department of State started with Appearance Enhancement and Barbers for the first one because the state already had the e-access system, which did offer a lot of benefits to the industry by allowing online applications and whatnot. Unfortunately, that system didn't allow for us to build in a school piece to allow that kind of information to be uploaded, but this current system does. We do it for Appearance Enhancement Barbers where we interact with the schools and the schools can affirm continuing qualifying ed. So we intend with the new system to do that for real estate, both for qualifying education and also for continuing ed, where the schools will have the ability to either log into an account and upload it or do a direct interface with the schools. But that is in phase 3 or 4. So that is definitely something that's doable and something that's definitely on our radar.
And to address Ms. Pinola's suggestion, that's what we've been discussing, is sending a notification out to the supervising brokers to let them know that, cite them to the article where they're responsible and that they're subject to disciplinary action as well for failure of the people under them to fulfill the continuing education requirements. But we wanted to give them the opportunity, we wanted to send them a notification first to let them know that we are doing this and that they will be disciplined going forward.
What do we know about the population of people that are non-compliant? Are they from any particular geography? What's the breakdown between salespeople that are non-compliant versus brokers? Or are we learning anything or slicing up the data to kind of learn more about the nature of and demographic of the non-compliant population?
Jody, can you speak to that?
Yeah, I mean, I think we audit half the audits that we do are for brokers, and we do find that non-compliance is higher with the salespeople than with the brokers. We audit all across New York State, so it's not in any one geographical location. We try to get random, samplings of all the areas. But it's definitely higher in, I don't have the numbers, but it's definitely higher non-compliance with the salespeople. So if we can encourage the brokers to, relay this information to them, and they can ensure that they do complete the continuing education before renewing. A lot of the initial problem seems to be also we get a high rate of people that don't respond to our initial audit letter. So what we're going to do is CC the broker, and we can do that through e-access. CC the broker, inform the broker that one of their salespersons are being audited, and that may, stimulate a response. We get a lot of non-responses, and I think maybe those are people that don't work full-time, they're not in the office that often, maybe the letter sits there, they don't respond to us. I'm not sure, but this hopefully will improve the situation.
Any other questions? All right, moving on to the next item. We'll receive an update on enforcement actions. Jack Vilello.
Hello, everybody. I'm here to report that as of today, Licensing Services has approximately 394 open real estate broker and salesperson investigations, which is rough, and that's 394 complaints basically out of approximately 583 complaints about all our disciplines. So roughly 68% of our investigations at this point involve complaints about real estate brokers and salespersons. Ms. Clark had mentioned that we're in the middle of a lien program right now. And so the enforcement unit is, right now we're trying to modernize our activities, trying to hopefully make them more efficient, more effective. We have aims now to finish our investigations in 120 days or less. And we started, that goal went into effect in January 2014. And so far it's been very effective. It's still in the early stages, but we've been able to close over 80 cases this year alone in less than 120 days. And the complaints that we receive, since there's so many of them, they vary in nature. I mean, I'd be happy to go through some investigation types if you're interested. But with 394 different complaints, as you can imagine, there's a lot of different issues being raised. As far as our lien efforts, what we're talking about there is we're trying to speed up the process with the investigations. That means we're initiating contact with the complainants and our real estate licensees sooner. We're trying to do investigations less and less as field investigations, though there are some investigations where we have to have face-to-face contact with our real estate licensees. But other investigations we found don't warrant that, so we can easily conduct the same investigations that we've been doing for years by using telephone or email or faxing, and only if it's particularly necessary at this point would we require a meeting with one of our real estate licensees to go over a particular complaint. So overall, we're trying to make the investigation process a better experience for the complainants and our licensees.
Can you name like a few of them so we
Yeah,
know?
where do they fall? What category do most of them fall into?
Okay, well, this is all anecdotal, but
Yeah,
I can give you a traditional one that we still receive for as long as I've worked here is the situation where we have a complaint involving a rental transaction where prospective tenant gives a deposit to the broker in connection with a transaction, and then for whatever reason the transaction is not consummated, and then the licensee decides that for their time and efforts they're going to convert that deposit to what we might perceive to be an unearned commission. And to make it worse, I guess, more often than not, they would commingle these deposit monies into their own private or personal bank accounts. And sometimes when the complaint is filed, upon receiving the complaint, they might choose to give the money back. Other times they choose not to. They still feel that they've earned that money. We also get complaints about allegations of brokers failing to disclose their agency relationship to their to their customers. That's a common one. And we've also had some more complaints lately involving unlicensed real estate brokers in New York City. In those ones, traditionally what we do is we conduct the investigation, gather evidence of the unlicensed activity, and then forward it to our counsel's office. And our counsel's office would decide if we have enough evidence to warrant forwarding that file to the Attorney General's office for any type of criminal or civil prosecution.
Can I say something real quick?
Sure.
I have one question. Honestly, I really don't know the answer to this. I don't personally do this. Are real estate agents able to charge an application fee? Because I'm getting so many people who are coming to me telling me that real estate agents are charging, $100 application fee for a rental, $40 non-refundable, whether they find the apartment or not. I don't think it's ethical. I don't do that. I'm in the business of much higher money than $100. So I just want to know: are they able to do that? As far as real estate agents not licensed, this is something that I thought is very important. I know we do this for contractors and for loan officers. What if we were to have, and I've spoken to numerous people about this, real estate agents put their license number on their marketing material? That makes the public know there is a higher official that they have to report to. And if you don't have a license number, I was showing earlier the article that came out in the Daily News 2 days ago of the man who was acting as a fake broker and was showing abandoned houses. Now, if real estate agents, just like loan offers and contractors, are required to put their license number on there, I teach, and no one in my class ever knows who licenses real estate agents. They don't know DOS, they don't understand that. But if you see a license number, you're going to research it because you know that they can't just wake up one day and become a licensed agent. And I think, everyone may not agree with it, but I don't think it hurts to just have your license number on your marketing material.
I've conducted several interviews with local television stations dealing with complaints from individuals, and whenever they ask for tips, that's one of the references that I make, is the fact that they have to request the license of the individual and verify that with us over at the Department of State. One of the issues that we've encountered, particularly in New York City, about unlicensed activity are these multi-service agencies, where a lot of people may go, they're looking for a job and an apartment and something else, and the individuals that are offering these quote-unquote services pose as real estate brokers, real estate salespersons. Yes. So we have been working with the local authorities in New York City, with the Department of Consumer Affairs, with local TV and radio stations to educate the public about the fact that just because they're offering services doesn't mean that they're licensed to offer all the services that they list in those particular places. But it continues to be the number one target area, for notary fraud, for real estate, for job service agencies. It continues to be one of those areas that we see is the focus.
So what does everyone think about the licensing number on your marketing material? Like I said, I spoke to her the other day, and she said she has a friend who finds apartments for a broker and gets paid and is not licensed. And she talks to the people. I mean, I can tell you, I get hundreds of these that people present to me of these situations.
I would say, I think it's a good idea, one. Two, I think it's one of a plan of attack if we decide to go that route is really public education.
Absolutely.
Because I can tell you absolutely, for a fact, I invest a lot in Brooklyn. There is a whole subculture of unlicensed brokers that are extremely active and boldly active. So I think it's when people don't understand that that's a violation and or there's a consequence to acting with them. So I think there's an element of it that has to do with notifying the public that we're cracking down on this. Brokers need to be licensed. But I can speak specifically for Brooklyn. There is an extremely active subculture of unlicensed broker, like very active.
The idea of putting the number on the card, it is a very good idea, but on the card, if they fabricate one thing, they can fabricate a number. And if you have a number on the card, you have to be able to check it somewhere. So where will you check it? You'll go to the Department of State website. Well, the Department of State website right now is very easy to check to see if your agent is licensed, if the brokerage firm is licensed. I'm all for security, but you'd have to have a place to check that. And so right now, they have to go to the Department of State website. And I think right now, the Department of website has made it very easy to check to see if an agent is licensed and a brokerage firm is licensed.
Which I just mentioned, this is why we were so careful with the team names.
Yes.
When you had the Smith team, it has to be the Mark Smith team, so someone can check on Department of State. That's why we did that.
My point is, you can go to the DOS, but the average person doesn't know they have the DOS. But when you have a license number, you know there's someone above this person to check it. And when you see a license number, you know that this person is regulated. You know that there's some type of structure.
True, Trish, but if they fabricate a card, they're going to fabricate the number. Once they see everybody has a number, they're going to put a number on it, and the person will see a fabricated number. There is a higher authority you check on the Department of State website. Again, I think all security measures are great, but how far do we go? I mean,
Would the broker's number go on there too?
Once
if
again,
it's a sales agent? So.
With Dale, I'm talking about Brooklyn. I mean, I know in other areas, I can't really speak on that, but I know in Brooklyn, they don't know. And even if you fabricate this number, at least the consumers know there is someone. And you know what? Now I know I can go look up that number and see. You can fabricate a number, but if I check that number and it's wrong, then I can report you. I know there is someone I can report you. But without that, people think that you wake up one day and you become a real estate agent. That's unfortunately in the market that I work in, that's what people think. That's what they think. They think you can wake up tomorrow. They said everyone is doing it. Dale said it. There is a whole huge market of active people who are doing real estate, and what's happening is the consumers now have lost faith in real estate agents because there are people who are doing it who are not licensed. And there are people who don't want to take the course.
Aren't they required to show their pocket card? The pocket card has their picture, has the license number on it. So.
And it requires to say licensed real estate salesperson. So isn't that indicating something?
They don't know, but the consumers don't know this education to ask for it. The consumers don't know.
Right, but
it's a different market.
I think you
in
might have
Brooklyn.
to. I think you might have to be there to see it.
Yeah, you.
Maybe we can table it and see.
I would also suggest, Eileen, that if there's, and Jack might be able to speak to this, if someone puts a fake number on the card, then for enforcement purposes, that shows more intent than if that number was not on the card.
Loan officers have to do it. Like it's nothing.
Do you know what I would suggest? Whitney, can you hear us?
Yeah.
Whitney?
Reggie, what?
Hello.
So Duncan asked me if we prosecute people who are unlicensed, and unfortunately our statute only gives us jurisdiction over licensed brokers and salespeople. So our only option when we come across people who are unlicensed is to refer them to the Attorney General's office for criminal prosecution.
And can I address something that was said? One of the board members mentioned that this is rife in Brooklyn, and if there is evidence of massive noncompliance and massive unlicensed activity, get it to us, because we'll certainly do the investigation, and then there's a referral. And I got to tell you, the Attorney General is far more interested in large-scale noncompliance than he is in a single instance of noncompliance.
Mm-hmm.
If it's worthy, if this is really happening on a large scale, I think that's something the AG may be interested in. So certainly, let us know.
The best way to do it is send out testers. The best way to do it. Go on Craigslist, send out and act as a consumer and takes people cards, and you will come back with a caseload of non-compliance.
But if you're aware of unlicensed activity, and you have people who are telling you that, tell them to complain to us.
No, give it a try.
Again, I don't know how much time we want to spend on this debate, but I'm just talking to kind of give color because I was an active investor in this market. It's but I mean I'm not an investigator, right. to go figure this type of stuff out in my personal time. But it's just a really large subculture. It's the Wild West. Right. People don't even think about getting licensed. People are in neighborhoods. They have access to properties for which there are large demand from cash buyers. And you have access to property. People don't ask if you're a broker. That's why I said it has to be a consumer-driven education where it's just kind of like, hey, you can't do this, or who do you, people are off HUDs. They get paid in cash. There's just a whole big thing. So I think what we have to think about, and today may not be the time, is what is that costing the city, or what is the implication of that to the state? And if it's big enough, then we have to do something about it. But, I think I'd have to agree with Tricia. If you had the right resource to just peruse Craigslist, you'd be amazed. You'd probably find 50% of the people you were talking to weren't licensed brokers.
But with what you're saying, us requiring our licensed people to put in numbers and everything, I can't believe the cards that these people are giving out have anything that's compliant with what we have to do in your license.
But
They're probably just doing numbers, putting the word broker on it, God knows what. Will the consumer know that the license number should have been there and missing?
But when the consumers have issues, now they know that there is someone, they can find out that there is someone regulating them, that there is a higher authority. That gives you the notion that this person is not just this person. When I teach, no one in my class knows about DOS until I tell them. They said, I thought I could
But
just
again, if
become
the
one.
person isn't licensed, DOS really
it
can't
right?
oversee
Exactly.
But
them.
then they know to take it higher. But some people just don't know where to go, and that's just
Right. I think that we can go on this topic for forever, but particularly as to the neighborhoods that you're speaking, Ms. Francis and I have had several discussions about doing some education, particularly to address those neighborhoods, and obviously we would want to do it in a mass scale. So that our time and the time of the individuals that attend these sessions is well used. My suggestion would be if you know of any particular community organizations that are looking hard at this activity and would be willing to share information with us, we can definitely set up a meeting. I definitely invite DFS because I'm pretty sure that it's not only on the real estate side, the insurance and the mortgage side of it. It's probably involved as well.
Sure.
And we would do a joint effort on that, if that's okay with you guys.
Of course, yeah. I mean, this is obviously something that we see quite a bit. I think that it sounds like the real estate brokers don't have to put their license number on their cards and marketing materials. In the mortgage industry, actually, licensees are required to do that. So it's, and that I think is sort of something that does raise a red flag when it's not there, when the license number is not there.
Before we leave, Marcos, could I just ask, I'm very happy to hear about your decision to complete investigations in 120 days. I think that's wonderful. I think at the last meeting, Diane Ramirez brought up, though, and I don't know if your policy has changed, when a file is closed, would you notify the broker of record that the investigation is closed?
Yes.
Because, so that policy then will be in effect.
Yeah, they should have been doing that for many years.
Well, they hadn't been.
No.
But now there's there's closer supervision as to this issue happening. And one of the things that I wanted to clarify with respect to the closing of the record is that the 120 days is for the investigator to conclude the investigation, meaning that either it encourages settlement for the parties to the extent that there's a possibility of settlement. The file is forwarded to counsel's office for appropriate discipline, or if there's a determination that there's no disciplinary matter or no jurisdiction for the Department of State, then that action is taken within 120 days. It's not just automatically closed, and obviously there's always review by counsel's office.
As long as when you reach that final, that there's nothing here, you would let the principal of the firm know. It's closed.
Right.
That's great. Thanks.
Great.
And that's part of the reason why we did this also is, as you know, we get complaints in many different formats. Sometimes people think that they complain with just making a phone call. What we're encouraging everyone to do is that the formal procedure is to go online, fill out an online complaint, and attach any documents that they feel are relevant to support their case to that. What that allows us then is to have an email address for the respondent, for the complainant, and then we also like to have email communications with the respondent going forward, so that once the file is closed, then we can make that automatic notification via email rather than rely on the mail or any other sort of informal communication to go out.
Mm-hmm.
Okay, but you say that is the policy.
That's the policy.
To my knowledge, the notification is not happening. So, if that could be looked at carefully, that would be great.
Sure.
Otherwise, it's just always an open case with the person that got the complaint.
No, yeah, I agree. It shouldn't be open-ended like that. We're required to notify all the parties as to the disposition, so that's important.
Yeah, great. That's very important. Could I you asked a question about applications. I didn't hear the answer. about his application fees?
She doesn't have the answer. I was
Oh, okay,
just
so-
bringing it up, right?
Oh, you were just bringing it up.
Can you legally charge an application
Yeah,
fee?
that's what I was
Okay.
asking, and I didn't get an answer.
Can you describe what the application fee is? Is it going to a principal? Is it by the broker? I mean, what is
It's
this
by the
application?
broker. You walk into a
For
real
the
estate
broker,
office.
by the broker,
For-
for the broker?
Yes, you walk into a real estate office and you're looking for an apartment, and they hand you an application to fill out, but there's a fee that you have to pay to fill out that application. So I've heard of people charging $100, $40 for this application, and that is just to fill out the application for an apartment, and it's non-refundable. And it doesn't get applied to your broker fee. It's just to fill out the application. I was just asking, is that legal?
But, it depends it depends what it's for and what they're asking for. These things are a matter of contract. Mike tells me here that sometimes that includes a background check.
Credit check.
That's really a fee
Credit
for a
check.
background
Credit check.
So what I would like to see, or we can do some homework, is under what context this application fee is charged. Because it's a general statement. I just don't know. All right, I'd like to see
Oh,
the
it's just to
document.
fill out the application. Just to fill
Just
out.
to fill out the application.
Just to fill out the application.
So in matter of
and-
contract, the prospective tenant, the broker says to the tenant, all right, to engage my services, you're going to be charged $100 non-refundable application fee?
Yes.
I think if the individual agrees, I think that's lawful.
Okay.
Do I have,
It's a matter
the
of
longtime
contract.
former counsel,
It's a matter of contract.
if it's disclosed, it's always the caveat that this has to be fully disclosed and understood by the prospective client.
Thank you.
But before we move on, I have one more question on enforcement. You mentioned, Jack, that 68% of the department's complaints are on real estate brokers and salespeople. Is that roughly proportional to the number of licensees, or is it higher?
I don't have the answer to that question.
Is it surprising that it's that high?
It's higher than the proportion, given that the real estate brokers is one of the top 5 categories, but appearance enhancement professionals and notaries are also, comprise a large portion of our population. So
Gotcha.
It continues to be an area of concern.
That
But
appearance
those, I guess I could understand why there are fewer complaints. But like contractors, I would assume there's a lower number of them, but I would assume there's sort of a relatively higher proportional number of complaints.
Yeah, I would agree. But we have, real estate licensees do comprise a large percentage of our licensees, so I guess it's not too surprising that we have a lot of complaints about them. Some of them are more obscure license types, we may not receive a complaint about them during the course of a whole year.
Right.
So,
Thanks.
I'm not sure if this is appropriate, Robert's Rules of Orders, but since we're under enforcement, in the April 24th minutes, under public comment period, Kathy Nolan had brought up an issue that had happened in, I believe, Nassau County, but has implications also, well, it says here certain municipalities in New York City, but it's also in New York City, where local laws were, she believed, and local laws and Turnipals that appear to require brokers to overstep their scope of practice. And I believe you were looking into that several months ago. I wondered if anything came of that.
I believe I'd have to look at my historical files on that. I know that one of the issues was resolved. I know there were two. There was the City of New York and there was Nassau County. I believe that we resolved it with New York County, and that Nassau we were trying to establish a dialogue with. But I'll take a look at my material, and I'll send the board members an update. We can certainly get it to the agenda for our next meeting.
Yeah, because I'd like to know what the resolution was. Okay, thanks.
Any other questions related to enforcement?
Big topic.
Good. I want to acknowledge the presence of Joe Burko with us. Thanks for coming.
sorry for being late, everyone.
Next item is a report from the Education Committee.
Yes, okay. Well, again, I want to thank Mark and the Education Committee for their efforts as we work to revise the hours dedicated to each of the topics within the 45-hour broker course. We haven't met in a bit of time, but we hope to get geared up again. The bulk of the work was done. We went over topic by topic in each segment, and we were able to come up with about 11 hours that we reducing from various topics. Our goal is to add the majority of the hours to the topic, the broker's office, operation, management, and supervision, with maybe perhaps some time to agency disclosure. And as we can see with our CE efforts here, this is very timely. And the general consensus from our survey and our members and the public is this topic really does need to have quite a bit, at least maybe up to 10 hours additional in it. So the committee will continue to work on that and report back. Any questions? Okay.
No questions? Well, thank you. Before we move on into the action items, I would like to ask counsel, have you been able to determine?
Yeah, so I got good news and bad news. The good news is, for purposes of counting, the total complete complement of the board is 15. You need a majority of the currently serving members of the board to constitute a quorum for purposes of taking a vote. That would be, if we had a full complement, 8. So my question to you, and I don't know the answer, is first of all, do we have the full complement of board members? Are there any vacant seats?
There are 2 vacant seats, according to the list you have.
There are 2 vacant seats?
According to this list.
Okay, so if that's correct, then our complement for purposes of deciding if we have a quorum is going to be 13. So 13, majority would be 7. And I think that's significant, right? How many board members have we today?
7.
We have 7.
7.
So if in fact we have 13 currently serving members, then 7 is the number that's needed to take a vote.
Great.
Thank you.
Okay.
So indeed, we do have quorum to take a vote, and I would like to then move back into the approval of the April 24th, 2013 and August 14, 2013 summaries. Has everyone had a chance to review them?
Yes.
Can I have a motion?
Motion to approve?
Motion to approve. Somebody second?
Second that.
Mr. Berto seconds. Anyone opposed? Motion carries. Both the April 24, 2013 and August 14, 2013 summaries are approved. And now we will go to our third item, the action items.
Record retention?
Yes. Yes,
Okay.
go ahead, Dan.
So this has come, I understand, this has come before the board before, and the board approved the motion proposed. No comments were received on the proposal, so we're now ready to adopt. There has been one non-substantive change, I think you have copies in front of you, and that is simply the moving of a single sentence, which was an exception for if the broker did not or could not obtain a paper copy of, let's say, contract of sale or whatever it is that he's required to maintain, that certainly need to maintain that, but just maintain the record of it. That sentence was placed originally in paragraph A. I think that was inappropriately placed. It really needs to be behind the requirement for the retention of the documents, so it's been moved to sub 1 in paragraph A at the end of that paragraph. It's non-substantive, but I think it's clearer. That's the only change to the rulemaking. And so if everybody's in agreement, or if you have any questions, I'd be happy to answer them. If you're in agreement,
I have a
Yes.
question, Diane Ramirez. It states in paragraph A, it's for 1 to 4 family. And I know in our agency disclosure to accommodate the New York City marketplace where we have co-ops and condominiums that do not fit under that. Should that be also, I think we said including co-ops and condo in our agency disclosure to cover our product downstate. I recommend we put that in, otherwise it's unclear to me.
Well, what does, I'm going to defer to Whitney on this since Whitney carried this rule through.
It should, yeah, the statute was changed to modify the definition of residential property. Originally it was 1 to 4 family dwellings, but that was modified so that condos and co-ops would fall under the agency disclosure. I think that Diane's correct. I think this should be modified to match the statute.
So it should just say residential property?
Residential property.
Which would then include the co-ops.
Right.
We can do that.
But if it just says residential property, what about multifamily? That's all residential.
I think if we say residential property as defined in Article 12A of the real property law.
Here's what I would suggest. Here's what I would suggest, because we have to be very precise with the language of what that is, otherwise it's going to cause confusion. And I think it's going to take a little homework. I don't believe it's a substantive change because the spirit and intent of the language is the same. So it doesn't have to go back to another rulemaking, but I think we have to really think about what we put in there. So what I would suggest is that we agree that we need to make sure that we, for the public, include that so the public knows and the brokerage community knows. But that what I would ask for when the vote is to occur is that you vote to approve the rule if you are so inclined, with the caveat that we would put in the appropriate language to effectuate the intention that was just expressed. Wait, it sounds way too boilerly.
And I so move.
And then we can send the final language to the board members by email to make sure that everybody
We'll circulate it.
Yeah.
If there's any issues, folks can get back to us. Yeah, okay.
And consequently, if I may, I think that to address Sandra's comment, I think multifamily falls under the commercial category. So I think that should be
Not
in a
necessarily.
separate one.
If it just says residential property, if it's
Residential
classified,
is 1 to 4, but also includes, of course,
well,
co-op
then it should
condos.
say that. 1 to
Yeah,
4
it should be
co-op
clear.
condos, yeah.
It should be clear.
But
Definitely
residential
co-op condos.
property.
Including co-ops and condos.
Yeah, I
Right,
think
simple.
this
Right.
plus co-op and condos. I think is-
Okay.
What's your suggestion? The 1 to 4 family?
1 to
including
4
co-ops?
families,
Up
which
to
includes
4.
co-ops and condos, or including co-ops and condos. You know, the KISS principle.
Yeah, yes.
That's
So
a
multifamily
good
would
legal
not
principle.
fall
I like
under
that.
Right, it's up to 4.
Yeah, multifamily is a different category.
Right.
Justice
That's what we're
Frankfurt,
saying.
if I'm not mistaken.
What?
So that's probably how it's going to read, but we'll do a little homework and make sure that that's the best way to put it and circulate it to you. If we have a difference of understanding, you'll get it and you can comment on it. Otherwise, we'll do what goes.
Great.
Any other questions? Marcos, do you want to put that to a motion and vote?
Yes. So can I get a motion to approve the language for the records retention regulation subject to the modifications proposed to council? Dan Ramirez, second. Eileen Spinola, seconds. Anyone opposed? No opposition, the motion carries.
Great.
Thank you, Dan.
We'll get the language out to you forthwith.
Next, we have new business. Anyone has any new business to bring up to the board? Duncan, you've been extremely quiet today.
I've been too noisy in the past. I'm trying to calm it down a little bit.
All right. Being that there's no new business to bring forward to the board, we'll move now to the public comment period. As we've said before, public comment period is an opportunity for members of the public to address the board as to any issues that they feel should be under consideration or review of the board. It doesn't necessarily mean that the board will take any action on those items, nor that there needs to be interaction by the board, unless any particular member of the board would like to address that and make it into a business item. Having said that, is there any member of the public in New York City that would like to address the board on a particular issue?
Yes.
Nope. Albany?
Yes. Actually, this is good here, right?
There you go.
Good morning, Anthony Gatto, counsel to the New York State Association of Realtors. During our meeting in February of 2014, the New York State Association of Realtors approved a proposal to the State Board of Real Estate to shorten the minimum number of hours for continuing education from 3 hours to 1 hour. And then furthermore, following that, in the same section of the regulations under 177.7, to bring the computation of instruction time for CE courses in line with the computation of instruction time for the basic salesperson and brokers course that can be found in 176.5. This would permit CE courses to be done as breakfast of knowledge or lunches of knowledge, as well as covering very specific topics that could not be stretched out into 3 hours of instruction time. So the New York State Association of Realtors would like to propose that change to the State Board for consideration, and I will give a copy of our proposal to Whitney to distribute to the board after discussion. And I'll take any questions if any board member has any.
Question. You're talking about the fair housing, right? No.
No, this is regular CE. So right now, a CE course can't be in less than 3 hours.
The minimum you can have. Now it's 3 hours.
That's what I.
And I can tell you, as an attorney, they allow our continuing education to be 1 hour or more. We also found out that New Jersey's real estate licensees will also have a 1 hour minimum for CE time. So there is precedent within the state and other states that border us as far as the length of time for CE.
Per class. Yeah. Per class.
Yes. That amendment would also reduce the amount of time per hour from 60 minutes to 50 minutes of instruction time with a 10-minute break as is set forth for the salesperson and brokers courses.
We're doing anyway.
That sounds fine to me.
Yeah.
I'm sorry, so you're proposing that, I get the hour reduced to 50 minutes so that we all tell time the same way. You don't tell time differently in a qualifying course than you do in a continuing ed course. That's terrific. All right. Did I just hear you correctly say that in a 50-minute class they can have a 10-minute break?
No, it's set up the way that it's set up. It's a 60-minute class, 60 with a 10-minute break, which makes it 50 of instruction, 10 of break, as it's set forth for the salesperson and brokers course as well. That's currently in regulation. Does that make sense?
Yes.
Okay. Any questions? Really? Oh, thank you very much. That's great.
That seems fun.
Yeah. So I'll give a copy of this to Carol so that it can be included in your meeting folders for the next meeting, and we'll add it as an item of discussion.
Should that go to the Trends Committee at some point between the next?
Yeah, I think we should
Yeah,
get
we just the Trends Committee to discuss it?
Sure.
Okay. All right. Duncan suggested that the Trends Committee meet to discuss this before our next board meeting. So we'll have Carol set up that meeting.
And for purposes of being efficient, I think that the Education Committee should also, receive that.
Oh, thank you.
Okay.
So, if both committees could, perhaps meet
Okay.
and discuss it together, just for purposes of efficiency.
Thank you.
Is there anyone else that would like to address the board in Albany? All right. Before we move on, I wanted to make sure, I mentioned this to the folks in New York before we started the meeting. The Department of State, the Secretary Perales, in his function as chair, received a letter dated May 15th from the National Association of Exclusive Buyer Agents with an address in Avondale, Arizona. Several board members here in New York have expressed that they received the same letter or letter raising similar issues. Our counsel's office will be addressing this letter. I'm preparing an appropriate response on behalf of the secretary, but also, of course, in his capacity as chair on behalf of the board. If there are any comments or any issues that you would like to address, please refer them over to Whitney or Dan for them to consider them in our response to this letter. But from my understanding, at least, it seems like most of these issues are already addressed in the New York State statutes. That probably is going to be the approach that we will take in response to the letter. Having said that, there doesn't seem to be any other issue before this board. If I can have a motion to adjourn. Dan Ramirez, second. Anyone opposed?
No.
No? Meeting is adjourned. Motion